Good afternoon, students. Today we are here to revise on the next topic of Unit 1, which is there in your syllabus. That is the prospectus and statement in lieu of prospectus. To begin with the prospectus, please understand. In the company Act 2013 defines a prospector under Section 270, Clause 70 of the Act. Before that, understand that as per the Companies Ordinance 1984, prospectus was being defined as a document prescribed or issued as a prospectus, like kind of a circular, a notice, or kind of advertisements for the subscription or purchase of any debentures, body corporates, inviting deposits from the public, public to public other than the deposits by the banking company. But later on, in 2013 amendment of Companies Act, clause 70 has defined and given a watershed definition on this particular topic. That is, the prospector means any documents which is prescribed, which includes any circular or any kind of a document, advertisement, or other acting as an invitation to offer from the public. And such an invitation to offer should be for the purchase of any security of a corporate body. So it is basically it is a kind of advertisements. Further, in section 26, if you kindly see, you will be finding that it deals with the matters which are related in prospectus. What are the, if you talk about which companies are required to issue in prospectus, every public limited listed company who intend to offer shares or debentures can also issue prospectus. Further, the private companies who wants to convert into public, who sees to be want to convert into public and intend to offer the share or debenture, can also issue a prospectus. The requirements in this category, that is, it should be in writing. A document should be following in writing, and of course it should be issued by behalf of any body corporate, issued against the public, or it should act as an invitation of shares in debentures for a body corporate. Further, in section 26, as I've said you, what are the things required in prospectus, or the contents are like every prospectus issued on behalf of public company should be either with reference to any formation or by on behalf, shall be dated and signed, and shall state the names and address of the office, the chief financial officers and the legal advisors. Second, the date of the opening. Third, the statement by the board of directors, the details, the consent of the directors, authority of the issuance of this resolution, capital structure, main object of the present business. Further, it also talks about the minimum subscriptions required, the extent, any litigation or legal procedure, if pending in the governmental or tribunals, any disclosure that is to be made. So these are the certain kinds of contents that are mentioned in section 26. You can revise them. Further, I have clarified and defined in brief in the study material that will be provided to you. So further, the section 26 also talks about the contravention of the act. If a prospectus is issued in contravention to the previous sections, then the company shall be punishable with not less than 50,000, or which can extend to 3 lakhs. And every person who is a party to such issuance shall also be held liable, which can include an imprisonment for a term, or a fine not less than 50,000, which may extend to 3 lakhs or more. What are the types of prospectors? There are 4 basically types of prospectors. That is the abridged, deemed, shelf, and red herring. The first one, the abridged one, which is mentioned in section 2.1, which means that abridged is something which talks about that a company cannot issue application for the issue of debentures. It cannot do so if so contain the salient features of the prospectus or memorandum. This is known as abridged. So in other words, abridged is one that contains the salient feature of the memorandum. Second is deemed. Section 25 talks about the deemed prospectus, which includes that where a company allots or agrees to allot any share or debentures with a view to these offered or for sale So in that category, of course, will be considered to be a deemed prospectors. It also, in other words, it also means when any companies to offer securities to sell for the public allots to or to allot securities will be considered the deemed prospectus through which the offer is made to public for sale. The document is deemed to be a prospectus of company for all the purpose and for the all the provision of contents and liabilities. Further, in SEBI versus Kunam Kulam paper mills, it was being opined by the court that where a rights issued is made to the existing members the right to renounce the favors of the other, it becomes a deemed prospectus if the number of such other exceeds 50. For, further, the shelf prospectus, if I talk about, the shelf prospectus is again, it can be defined as a prospectus that has been issued for any public financial institution, company or banks for one or more issues of securities or class of securities as mentioned in the prospectus. And when the self prospectus is issued, then the issuer does not need to issue a separate prospectus. He can offer or sell without issuing any further prospectus. The same is mentioned in section 31 of the Company Act, and the regulations are to be provided by the Security and Exchange Board of India for any class or classes of company that may file a shelf prospectus at the stage of the first offer of security to the registrar. Secondly, if you talk about the third category is the red herring. The red herring prospectus is again a prospectus which lacks the complete particulars about the quantum of the prices of the security. A company may issue a red herring prospectus prior to the issue of prospectus when it is proposed to make any offer for security. This type of prospectus needs to be filled needs to be filled with the registrar at least 3 days prior to the opening of the subscription list or the offer. The obligations carried by a red herring prospectus are same as that of a normal prospectus. If there is any variations between a red herring prospectus and prospectus, it should be highlighted in the prospectus with the variations. The applicant or subscriber has a right under section 60B clause 7 to withdraw the application on any intimation of variations within 7 days of the such intimation, and the withdrawal should be communicated in the writing. Further, moving on is the requirement of prospectus. There are n number of requirements. The first is prospectus must be dated, that is the publication date. It must include an auditor report for at least 5-year profit, and it is to be prepared being a date not more than 120 days before the date of such issue. It must be issued and published not less than 7 or more 30 days. If the prospectus includes a statement made by an expert, then the expert must not be engaged or interested in the formation or promotion in the management of the company. In case of a listed company, approved by SEBI, must be obtained within 60 days at the date of the issue. However, commission may impose such condition as may deem necessary. Further, a copy of prospectus must be sent to the registrar before the issue of prospectus. Seventhly, registrar shall not issue the prospectus unless the above requirements have been mentioned, and a sufficient number of copies should be issued as per section 53(1) and shall be made available at the registrar office of the company with the stock exchange at which the company is listed. Moving on is the liability for misstatement in the prospectus. What is the liability of misstatement in the prospectus? Please understand, those who issue prospectus holding out the public to the great advantage will be accrued to persons who will take shares in a proposed undertakings and inviting thee to take shares, faith or representations, and not only abstain from stating the fact, but also extend the quality and privilege which the prospectors hold as an inducement to take shares. In such liability, it can be happening to civil liability, and also again that is against company directors, and criminal liability, which can include the company, the director, every person included in the prospectus, every promoter, and every person authorized to issue the prospectus. So the entire details of such is also mentioned in section 65, section 62. The civil liberties are being dealt in section 36 to be read with section 62(1), and criminal liability is to be dealt with the with section 63 clause 1 and to be read with section 34. So these are the entire sections that you got to read in details. Further is that remedies against the company, that is the rescissions of the contract, right against the damage for deceit, compensation damage for non-compliance, damage under general law. Remedies against the directors, if we talk about against directors, the remedies can be the compensation if the liability consists in paying the damage by way of compensation to the aggrieved party. The compensation payable will be difference between the price paid and the values that are allotted. Damage for the non-compliance, the remedy to recover damage are not of the rescission. Damage under general law, if the plaintiff has to establish the following point, that has been a fraudulent misstatement or a false representation. And if we talk about the rescission of and further the rescission of the contract, if we talk about, the right to rescind the contract is available if the person can prove certain points, that is the statement is untrue, prospectus was issued on or by behalf of the company, statement comprising of material misrepresentation, that he has taken action promptly to rescind the contract, misrepresentation has happened out of the fact and not of law. And against the damage or deceit, this remedy is available even after the company has gone into liquidation only on certain ground. That is, person who issued the prospectus knew the statement is false, that the person was authorized to issue the prospectus, and that the allottee has suffered a loss due to such kind of misrepresentation. Moving in, this is the next topic, that is a statement in lieu of prospectus. Now, what do you mean by statement in lieu of prospectus? Statement in lieu of prospectus, it includes, or it means that if a statement which is delivered by a company having the share capital to the registrar for registration at least 3 days before the first allotment of shares or debentures under the following conditions. The first one, where a company does not issue a prospectus. Second, where a company has issued prospectus but has not proceeded with the allotment of public for, or gone into public for subscription. And further, what are the contents? If we talk about the content in lieu of the prospectus are almost same than just like the prospectus, that is the name, nominal share capital of the company, which is divided into number of ordinary shares as per the value per share, description of the business, name, address of the occupation, directors and everything, provisions regarding the appointment, voting rights, numbers and amount of shares and debentures, names, occupations of the vendor's property, and of course the amount payable in cash shares. So these are the certain things which should be in relation to the statement in lieu of prospectus. Further, one of the most important aspect that we have to study in this particular chapter is the difference between a prospectus and statement in lieu of prospectus. First one, in prospectus, it is filed by the public listed company. Statement in lieu of prospectus filed by a public unlisted company. Prospectus has been defined in section 2 clause 29. Unfortunately, statement in lieu of prospectus has never been defined. Prospectus is submitted to registrar, commissions and shareholders. Statement in lieu of prospectus is submitted only to a registrar. The documents in prospectus contains the advertisement or invitation for subscription from the public, whereas in statement of lieu of prospectus, no such invitation occurs in relation to any subscription. Further, in prospectus, the approval of commission must be obtained within 60 days before the issue of prospectus. But in statement, no such kind of advertisement or invitation is required. So there is no time period. In prospectus, no prescribed form is specified in the ordinance. But in statement in lieu of prospectus, a certain kind of prescribed form has been mentioned. No prospectus shall be issued unless the date of publication, copy signed, directors and everything has been mentioned. But in statement lieu of prospectus, it is filed with the registrar concerned at least 3 days before the first allotment of shares. So that was all for this session. But in case of any kind of clarification you require, you can mail me with your concerns, and I will be in a situation to mail you back or to reply if any. That was all for today, and thank you and have a nice day.